All right. So thank you so much again for coming this morning. We're going to be talking about reopening your businesses post-COVID-19. My name is Cindy Flynn, and I have Angela Saranzana here. Since we are attorneys, we do have a disclaimer for you that content on this webinar should not be considered legal advice and is for informational purposes only. Communications made through this webinar and or participating in this webinar do not create an attorney-client relationship. But of course, we're happy to talk to you afterwards to create that relationship. And we just want you to know that we're not responsible for any content that may be linked to third-party resources. With that, oh, Angela, go ahead. I know you'd like to add.
I do, and it's, if you've seen us on a webinar before, you know that I always need to add this. All of the COVID-19 related statutes, both federal and state, that are being issued right now, they're brand new laws, even though they've been in place now for what seems like an eternity. In the grand scope of things, this is all very new. There is additional guidance being issued by multiple agencies every single day to clarify or add to the laws that we have. So just understand that we are updating this information as we go along. The information that we're telling you today is the information that we know it as of this morning, which may be totally different this afternoon, which may be totally different by Monday. But you know, we're doing our best, and this is our understanding at the moment.
Yes, exactly. Thank you. So some of today's topics, we're going to be covering the PPP program, safely bringing back your workforce, new hires, touching on independent contractors and employees, and AB5, and then working remotely and some things you can do. Also, we've come up with a number of things that we want to provide you after the webinar, so you'll get, hopefully today, a link to this recording in case you miss a portion of it. And also, we put together an addendum for your employee handbook that you can easily just attach onto your current employee handbook that we thought might be helpful for our listeners out there today. I'm happy to send it to anyone, you know, who needs it, and you can, you know, forward it to any business who you think might it might benefit. We also created a template welcome back letter to send to your employees as well. And so both of those things will be included. And then as we go forward, there is Angela and I love to take questions throughout the presentation. And there's a Q&A button on the screen that says, it basically allows you to ask questions and allows us to answer them. And we can either read them out loud and answer them so everybody can hear, or we can, you know, type out an answer, as Angela already answered our first question. So thank you so much. And with that being said, let's continue. And just one other thing, you know, as the coronavirus outbreak continues to impact world markets and industries, you know, in the United States and all around the world, businesses are now being confronted with some very significant, unique challenges. And successful navigation of these challenges really requires thoughtful and comprehensive planning. You know, as we move forward, we're going to be talking about things that we think businesses might be exposed to. And I firmly believe we are going to see a rise in employment lawsuits in the next 6 to 12 months. And so we just want to do everything we can to protect, you know, everyone on this call, all the business owners we know, our clients, our friends, and keep them in business through all of this. And with that being said, you know, the CARES Act amends numerous provisions of federal law and tax law affecting both businesses and individuals. And so to get into just a touch of background on this, you know, when the CARES Act was originally signed into law on March 27th, it provided for $2.2 trillion in stimulus to individuals, businesses, and hospitals in response to the economic distress that was caused by coronavirus, caused by COVID-19, the pandemic that we're in. And it has since been expanded with additional funding. Part of the CARES Act includes a loan program for small businesses. I hope most of us have applied by now. It also includes, you know, 501c3s, nonprofits, and physician practices. But these loans can be forgiven through a process that incentivizes companies to retain their employees. And so for today, we're just going to focus on the PPP program. That's the Paycheck Protection Loan Program. And it was originally funded with $350 billion, and then on April 24th of this year, the government voted to fund an additional $310 billion in loans. And it covers the period from February 15th, 2020 through June 30th, 2020. And it greatly expands SBA loan eligibility. The loan program allows businesses suffering due to the coronavirus outbreak to borrow money for a variety of qualified costs related to employee compensation and benefits. And so what that includes is payroll costs. These are defined as wages, commissions, salary, or similar compensation to an employee. This also includes payment of a cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave, allowance for the dismissal or separation, payment for group health care benefits, including premiums, payment for any retirement benefits, payment of state and local taxes that are assessed on the compensation of employees. And it's important to note that it excludes compensation for employees earning more than $100,000 a year annually. So if you have somebody making $120,000 a year at your company, you're going to exclude that compensation that's above $100,000. So that $20,000 would be excluded. In addition to payroll costs, it includes continuation of healthcare benefits, mortgage interest obligations, rent, utilities, interest on debt incurred before the covered period. And the idea, just quickly to talk about payroll costs, this is based on gross pay. So it's the idea is that anything on an employee's paycheck stub is included. Anything not on the employee's paycheck stub is probably not included, like your quarterly taxes. And then we've been getting some questions on how to handle commissions for employees. And under the FLSA, to determine the rate of pay, you take the wages plus commissions divided by hours, and that's for an employee who earns commissions on top of the wage. So that's kind of calculation there.
I have a couple of questions that
Yes.
that I think are best answered live. One, do we know if the SBA will be extending the deadline of June 30th for states like California that have yet to open? At this point, we have not received any information that the deadline is going to be extended. The SBA and the PPP program are federal programs, so I doubt that that's going to happen. However, we will keep abreast of the situation and update our information as we know it. But at this point, we have no information that it's going to be extended. In terms of, are payroll taxes covered for pay over 100,000? No. So for purposes of forgiveness, and first of all, in terms of requesting the loan, and then additionally, in terms of getting loan forgiveness, all pay over 100,000, and that includes payroll taxes, is disregarded for purposes of the PPP. And then PPP covered payroll taxes. Does this include bonuses? Our understanding is that if they are mandatory bonuses, meaning they're built into the compensation structure ahead of time, then yes, that would the payroll costs would include those costs. However, I just want to remind you all that all compensation over 100,000 is disregarded. So if the bonuses are above 100,000, then they would not. If it kicks it over 100,000, then they would not be covered.
Right, and just one more thing on bonuses too. If you as a company, give a bonus every May for your employees, for spring or June for a summer bonus, something like that, I think you have a good argument to make that could be included in the forgiveness program. But if you're just doing it to essentially use up all the money so you don't have to return it, then it would likely not be covered. So please proceed with caution there.
And I think we're going to get into reimbursement, so I'm going to go ahead and save this question until later.
And then someone's asking if we can confirm that health insurance premiums are covered. Yes, they are. They in fact are. So for eligibility, you're eligible for this loan if you're a small business that employs 500 employees or less, or if your business is in an industry that has an employee-based size standard through SBA that is higher than 500 employees. People have been asking, how did Chick-fil-A get funded, and how did Ruth Chris and Shake Shack all get funding? Well, in addition to this, if you are a restaurant, a hotel, or a business that falls under the North American Industry Classification System Code 72, which is the accommodation for food services, and each of your locations has 500 employees or fewer, you are in fact eligible. So even though a lot of them are returning the funding, that's how they got it. Also, we represent a lot of franchise owners. Independently owned franchises with under 500 employees who are approved by the SBA are also eligible. And there's a whole franchise directory on the SBA's website to determine if you fall under there. Also, you have to have been operational as of February 15th, 2020. And then a common question we're getting is, you have to have employees. You have to, definitely one of the requirements, but a common question we're getting is how to calculate the number of employees. And it's either the average number of full-time equivalent employees of the borrower between February 15th last year and June 20th last year, or the average number of full-time equivalent employees of the company between January 1st of this year and February 29th of this year. And I also want to note here that an employee who is working 30 hours or more per week is considered a full-time employee for these purposes. So now the loan amount is the lesser of these two boxes, right? So it's the sum of the average monthly payroll costs times 2.5 plus any disaster loan taken out that has been refinanced into your PPP loan, or $10 million. And again, the term payroll costs is specifically defined to not include compensation of individuals earning more than $100,000 per year, and that's prorated for the covered period. The amount is intended to cover in 8 weeks of payroll expenses and any additional amounts for making payments towards debt obligations, which I'll get to on the next slide. So that's between February 15th and June 30th. Also, the interest rate on these loans cannot exceed 1%. So if if you are not able to use all of it for forgiveness purposes, you still get a loan at the rate of 1% or less. And the maturity of that loan is in 2 years. There are no prepayment penalties or fees associated with that, and all payments are deferred automatically for 6 months, even though interest still accrues. So I want to mention that. So these loans may be eligible for forgiveness on a tax-free basis. An eligible borrower for a loan guaranteed under the SBA is eligible for forgiveness, which includes your payroll costs that we just went over. It includes interest payments on covered mortgages, covered rent, utility payments, those types of things. Now, a common question Angela and I have been getting at this point is whether or not you can prepay rent for the next 6 months. The answer is no. You don't want to do that if you're looking for forgiveness. I mean, you certainly can do that, but you probably won't get forgiveness if you prepay your rent. And then also, throughout this, make sure you're checking in regularly with your CPA and your banker and your lawyer. Kind of keep the whole team up to date on what's going in. Angela, do we have some questions that we want to go over at this point?
There are actually two that are going to be answered on the next slide. The two questions are, after getting SBA funds, how long does a company have to get the employees on payroll? And then the other question is, if I have to use the PPP money for an 8-week period, but I don't have to hire them back until June 30th, that's at the end of my 8 weeks. So so after getting SBA funds, how long does a company have to get the employees on payroll? I think that's on the next slide, but you need to get them back on because the 8 week period starts the day that your first loan payment is disbursed. You need to try and get people back ASAP. There is a safe harbor provision. If you can get your FTEs back up to the proper number by June 30th, 2020, then your loan forgiveness, your loan forgiveness will not be reduced down. However, you have to make a good faith effort to bring people back in that 8 week period. You can't just, for example, wait until June 30th and then bring everybody back on that day. There actually has to be a good faith effort to bring the employees back within that time period. The other question is, if I have to use the PPP money for an 8 week period, but I don't have to hire them back until June 30th, that's at the end of my 8 weeks. I mean, this is a problem that a lot of our clients are running into. Again, the 8 week period starts from the time that your first loan payment is dispersed. I haven't seen any sort of official guidance from the SBA that allows you to defer out. However, I've heard anecdotally of people writing to their lenders and asking for the first disbursement to be deferred. I think it might depend on the individual lenders. So you may want to check in on that, but I've not seen any official guidance from the SBA about deferring the start date of the loan. Do you exclude benefits for staff who earn over 100K? So you would not exclude benefits for staff who earn over 100K. What you do is, I mean, benefits would be covered, but any of their salary and any of the payroll taxes that are assessed on that additional amount over 100,000 would not be included. You cannot prepay employees.
Right. Never, don't, yeah, not a, I love the idea behind it, but please do not prepay employees.
There is a question of what if you cannot open, how do you pay employees? I mean, that's sort of the purpose, part of the purpose of these loans.
Oh, yeah, that is a common question we've been getting. And what we're suggesting to our clients is to either, bring them back on and pay them and have them go off of unemployment, or, you're going to be able to use that loan at the 1% interest rate and repay it in 2 years. So it's really up to you on what you want to do there. But there's no good answer, which is why I think I don't want to give false hope, but I think like restaurants, for instance, a lot of them are not able to reopen and they've been funded. And so do you pay someone just to come in and sit there and do nothing? Or do you allow them to continue getting unemployment? And really, I mean, the decision is up to you at that point.
A couple more questions that are sort of in this wheelhouse. Can you prepay employee benefits like health insurance? No, you may not. That it's for costs incurred during the covered period. This also addresses a couple of questions that we have. For example, if you had rent that was deferred till April and you still owe it and didn't get your PPP funds until May, can I use funds to pay back rent for the past few months, and will it still be eligible for forgiveness? It depends on how your landlord structured it. If he is saying, okay, this is coming due, during the covered period, then yes, you would be able to. However, if it's past due rent, it would not be included because it's only for costs incurred during the 8 week period of the covered 8 week period starting from the date that you get the loan.
And then someone else is saying, banks are required to disperse the funds within 10 days of SBA approval. Yes, that is absolutely true, but you can still ask them to hold on to it for a few more days and fund at day 10, depending on your payroll schedule. It's just maybe a tool that you can do if you are probably with a smaller bank. I don't know if the larger banks are able to hold back for a day or two so that you can fit in your certain payrolls, but yes, they are required to fund and disperse within 10 days. So the PPP program, a percentage of laid off employees will impact an employer's ability to obtain loan forgiveness. So remember, the purpose of the PPP is to help you retain your employees at their current base pay. If you keep all of your employees, the entirety of the loan should be forgiven. If you still lay off your employees, the forgiveness will be reduced by the % decrease in the number of employees. If your total payroll expenses on workers making less than $100,000 annually decrease by more than 25%, loan forgiveness is going to be reduced by that same amount. And if you've already laid off some of your employees, like Angela mentioned, you can still be forgiven for the full amount of your payroll costs if you rehire them by June 30th of this year. And so the whole purpose, again, of this provision is to encourage employers to rehire any employees who have been laid off due to the COVID-19 crisis, and then borrowers that rehire workers previously laid off will not be penalized for having a reduced payroll at the beginning of the period. And then in updated guidance from the SBA, it was clarified that if you have an employee who has been furloughed or laid off and is offered to be rehired and then declines, that employee may be omitted from the loan forgiveness recalculation. So the employees declining, though, to come back to work must be documented in writing for your records. A couple other questions, I don't know if they're on here today, but questions we've typically been getting are whether or not you can bonus your employees. I know we touched on that a little bit, unless it's part of your every May or based on something specific, you probably don't want to bonus your employees. Another thing, though, that I think you can do, and Angela, I'd love to hear your thoughts because we haven't even talked about this in between us, but running a payroll early, I think, is totally okay. If you're going to, in order to get within that 8-week period, assuming that they already worked those days and they've earned those days, you're not prepaying them, but you're running a payroll early.
That's absolutely fine. The only thing that you want to keep in mind is just making sure that that doesn't throw off your payroll periods, meaning obviously under California law, you're required to pay someone for hours worked within a certain amount of time. So as long as you adjust it on the back end, meaning that the next payroll you can't just pay regularly, you may actually have to pay that a little earlier, then you're fine. It's totally fine to run payroll earlier for hours already worked in order to get in under the wire.
Okay. So to seek forgiveness, you want to document everything. An easy way to think about, having your employees back by June 30th is if you have an employee who is collecting unemployment as of June 30th, you will likely have an issue. If you do not have any employees collecting unemployment as of June 30th, you're probably okay.
Sorry, so are there placement fees for, replacing an employee who left covered by PPP? To my understanding, no, they would not be. That does not constitute payroll. That is a payment to a third-party vendor, and accordingly, it would not be included in PPP. What if employees don't want to come back because they're being paid more on unemployment insurance? It's a question we get a lot, but here's the thing. I think Cindy went over this before, but if they refuse to come back and you have written documentation that you gave them a good faith offer and they declined it, you can exclude them from the loan forgiveness calculation. You also want to advise them that if they refuse an offer to be rehired, they will no longer be eligible for unemployment. So, they sort of need to come back. Otherwise, they're not going to get unemployment.
Another question we are getting is whether or not you can incentivize employees to come back to work with some type of hazard pay. I probably do not recommend hazard pay. Angela, I don't know if you have any additional thoughts on hazard pay, but because it's a pandemic, there's no clear ending, right? Like when we go to war, there's a day where, okay, the war is over. But with this, I don't think that we're gonna see a clear day of this is when it ends. And so unless you are going to continue to pay hazard pay for a long period of time, until it's very clear that the hazard has ended, or unless you plan on increasing everyone's salary once the hazard ends to that amount. I probably wouldn't recommend it, but Angela, I don't know if you have any thoughts on the hazard pay.
I feel exactly the same way.
So going to bringing the workforce back. OSHA has specific guidelines about when, the stay-at-home order is lifted in California, or, if you are a critical business and you've been able to remain open. They identify certain risk categories to assist employers on determining what safety precautions are necessary. I strongly encourage everyone to check out OSHA.gov. There's a lot of information on there, and we just don't have time to go over it all today. But essentially, healthcare workers and healthcare support staff are considered that high-risk category. Employees with high-frequency contact with the general public, such as school staff, high-volume retail, those working in high-population workplaces constitute medium exposure, and then employees with minimum occupational contact with the general public or other coworkers are those office employees and remote workers. So employee categories to assess risk, we've broken it down into a couple different categories. Those who are returning from affected areas, those in close contact with those returning from affected areas, those who've tested positive for COVID, and those showing signs or symptoms. The bottom line is, a lot of people have not been traveling recently, but if anyone has been traveling, it's a required self-quarantine for 14 days. They may undergo mandatory health screenings that follow CDC guidelines. And then the same with those with close contact with others returning from affected areas. They may be required to self-quarantine and then also follow CDC guidelines. If you have an employee who has tested positive for COVID-19, it's very important to send them home immediately or have them remain at home. Immediately treat the affected areas in which the employee worked per CDC recommendations. You want to advise the employees and our customers who are in contact with the affected employee. You want to offer reimbursement for medical testing. You want to give workers' compensation paperwork because there is now a presumption that Workers' Compensation Board has come out with as of Wednesday night. And then also contact the CDC. It's important though, do not identify the employee by name. Obviously, if it's a small office and there's 3 people and one of them is not there, it might be obvious who it is, but just as the business owner, you do not want to identify that employee by name. If you see an employee showing signs or symptoms, you can send them home. I would still recommend you follow CDC guidelines and ask them for a release to return to work. Immediately treat the affected areas, and again, do not identify the person by name, but you may advise employees and or customers who were in contact with the affected employee. You can say that there's been no diagnosis, but that you're acting in an abundance of caution. And so in order to assess the risk, the employer may ask their employees to inform you if they have encountered someone who was diagnosed with COVID-19, or if they themselves have symptoms of the virus or have been diagnosed themselves with COVID-19, or of course, any recent travel to highly affected areas. You may not, however, target individual employees unless you have an objective basis for asking. And what I mean by that is, we've had people come to us and say, oh, I told my staff who's all over the age of 60 to go home. You don't want to do that because you're asking for an age discrimination lawsuit. So please do not start targeting specific individuals. Even though I know you mean so well in your hearts, we just don't want you to get in trouble with an age discrimination lawsuit. And then also you don't want to ask about any other medical condition or underlying disability information, anything like that. Now, with the CDC, here's the website. There are specific precautions. One of the things that you want to do is ensure that all frequently touched surfaces are cleaned, disinfected regularly throughout the day. That includes your tables, your doorknobs, your keyboards, your phones, your countertops, toilets, faucets, sinks, avoid conducting anything that could be considered a medical examination. And we've gone back and forth with this about taking the temperature of your employees. Yes, the EEOC has issued guidance that says it's okay for employers to take employees' temperatures, but we really recommend doing this in an abundance of caution. Anything that could be considered a medical examination might become an issue later, even if the EEOC says today in a pandemic, it's okay. And so if you are concerned about a particular employee displaying any symptoms of COVID-19, just send them home and advise them to consult with a doctor to receive a medical clearance to return to work. So bringing back the workforce, on May 6th, 2020, just this week, California Governor Gavin Newsom issued an executive order creating a temporary workers' compensation presumption for employees diagnosed with COVID-19. The presumption is retroactive to the date of the stay-at-home order and will stay in effect for 60 days after its effective date. Therefore, the presumption is effective for employees working from March 19th, 2020 through July 5th, 2020. So under the executive order, any COVID-19 related illness shall be presumed to rise out of and in the course of the employment for purposes of awarding workers' compensation benefits if these requirements are satisfied. So one, that the employee tested positive for or was diagnosed with COVID-19 within 14 days after a day that the employee performed work at the employer. The day on which the employee performed work at the employee's place of employment at the employer's discretion was on or after March 19th of 2020. The employee's place of employment was not the employee's home or residence, and the diagnosis was done by a physician, a doctor, essentially. So the presumption covers any employees who must work outside of their homes during the stay-at-home order at the employer's direction. While all essential workers who are required to report to work are covered, the presumption also covers any non-essential workers who performed work, labor services at the employee's place of employment. The presumption would not cover employees who went to their place of employment without their employer's direction. So it's important to note, though, that this presumption is rebuttable. So it may be controverted by other evidence, and so it's something to keep in mind. But ultimately, what you want to do as an employer, if somebody does get COVID-19, provide them the workers' compensation paperwork. With OSHA, there's the general duty clause where an employer is required to furnish to each employee a workplace that is free from recognized hazards that are causing or likely to cause death or serious physical harm. And employees may only refuse to work if they reasonably believe they are in imminent danger. And OSHA actually defines imminent danger to include any conditions or practices in any place of employment which are such that a danger exists, which can reasonably be expected to cause death or serious harm immediately. So that's the phrase there. It has to be immediately. Angela, are there any questions that we want to discuss at this point? I know they keep coming in.
Yeah, I'm still, okay, so here's an easy one. Will we have this information sent as a link? Yes.
Yes, happy to send this out.
Are we to enforce mask wearing if we are in LA County? You should be enforcing mask wearing regardless of where you're located. It is best practices under OSHA and CDC guidelines. And it's not really even a matter of compliance with the law. It's in your best interest to reduce the potential for infection. It is in your best interest to enact any sort of measures that will allow you to reduce the potential for infection. So one, yes, you are absolutely required to enforce mask wearing if you are in LA County, and two, you should be regardless of where you're located. Can you require employees and visitors to wear PPE? Yeah, absolutely. When they step into the facility, absolutely. You can say this is a requirement, 100%. Can you ask all your employees to take their temperature at home and just give an all clear on a daily basis as opposed to checking them daily? Temperature will not be, so yeah, absolutely you can. In fact, if you're going to be taking temperature, then, which Cindy has already sort of addressed in terms of what we're concerned about, if you're going to take temperature, this is actually probably one of the better ways to do it, if you have them take their temperature and then give you the all clear.
And then another question I see on here is, we got the PPP loan. What if we don't hire all our employees back? Will we be penalized? The answer is yes, we will be penalized. So, and there's a calculation for that. You can probably Google it and find a Google calculator that will help you determine that exact amount, or check with your CPA or banker, but you will definitely be penalized if you do not hire all your employees back. Okay, so another question I see that's come in: can an employee file a workers' comp claim to request a COVID-19 test? Oh, Angela says yes. Perfect. I think you were getting to that one, even though they have not received a positive diagnosis. Okay, I am just going to fly through the recruiting new employees. Just bottom line, make sure you are complying with anti-discrimination laws. We had one client recently come to us who put the word young in their advertisement, and now he's being sued for discrimination, age discrimination. So you want to avoid any references that would also contradict an at-will relationship. The California Labor Code specifically says that an employment relationship with no specific duration is presumed to be at will, but you can get rid of that if you say to somebody in a job interview, as long as you are a good employee, you'll continue to have a job. And then with bona fide occupational qualifications, if there is a good faith reason to have a characteristic, for example, a religious school can certainly require its teachers to be members of that school's religion, but religion would not be a bona fide qualification if it's a dental office seeking an office manager position. So keep that in mind. Criminal background checks. Employers with 5 or more employees are prohibited from asking about criminal background checks or criminal history information on job applications unless a conditional job offer has been made. There are a few exemptions. You probably don't fall under one of these though, so please do not be asking about a job applicant's criminal history. So checking references, there's no specific law requiring that you check a candidate's references, but courts have held employers liable for negligent hiring for certain acts of their employment, which the employer knew or should have known might occur. So reference checks are often part of the hiring process, but there are a couple things you want to look out for. You want to obtain a written authorization from the candidate that you are able to investigate all information that they are submitting on the job application. I can't even tell you guys how many cases Angela and I have had where an RN, a registered nurse degree, I guess, I don't even know, Angela, what you would call that, but a degree, I guess, an RN degree, that somebody has applied for a nursing position, it requires that degree, and then they find out 6 months later that that person doesn't have that. So we see these types of issues come up all the time. When contacting references, gain the maximum amount of information without creating that liability for invasion of privacy. You don't want to seek any information about the applicant's salary history. You don't even want to ask them about salary history. Additional guidance has come out and said you can ask a potential candidate for what a reasonable expectation, a salary expectation could be, but just be careful you're not asking about salary history or inquiring about conviction or criminal history, and then be aware of anti-discrimination laws as well. You don't want to ask about marital status of a candidate or the number of kids they have. I'm not really going to get into testing, but if you do test candidates, please run it by us or your employment lawyer if that is someone else. You know, it needs to be based on the job. And any test cannot, of course, screen out applicants with any disabilities unless the test is job related and consistent with business necessity. The key here when you interview candidates is keep consistent, mark those questions carefully if you have a number of people interviewing your job candidates, and also avoid overpromising. It could create an oral contract and, you know, you're not even aware that your job interviewer is creating that oral contract. Avoid any of these types of questions, please. And you can reframe questions. So do not ask if someone's a U.S. citizen. Ask if you are hired. Can you verify eligibility to work in the United States? Do not ask someone if they own a car. Ask if you have transportation to get to work. Also, do not write notes on the candidate's application or resume. An employer made a notation on an application of a candidate for a position at a jewelry counter of a large department store. And he meant the notation to mean no experience selling jewelry, but instead he wrote the words "no Jew," and then got hit with a religious discrimination charge against the store. So some common interviewing mistakes. Although there's no way to guarantee a candidate or employee won't sue, here are some of our common issues we see. Have you ever been convicted of a crime? Please, you know, years ago, we needed to stop asking this. It's called the check the box. It used to be a check the box section on an employment application. It's known as ban the box in California. I don't know what's going on with my slides. But basically, if you haven't updated your application since before 2017, you need to do so. Asking an innocent icebreaker of where you're from could certainly be, you know, considered a problem question. Where were you born? Where are you from? How long have you lived in the U.S.? Any types of those questions. When you're in doubt, don't ask. How much are you currently making? This is something you do not want to ask your employee or potential job candidates at all. If they voluntarily disclose that salary history, you can certainly write it down. You can ask about salary expectations, but just make sure you're not specifically asking about salary history. And then a common age discrimination lawsuit we see is when did you graduate high school or when did you graduate college? You can only ask a job candidate's age if the job has a minimum age requirement. For example, you're a bar and you're serving alcohol. And the number one thing which I see happens a lot is, are you planning to get married or have kids soon? And those are questions related to marital status and parenthood. These are off limits. Angela and I had a client a number of years ago in Santa Monica, you know, and he's a sarcastic guy, good heart, CEO. And he said, an employee came up to him and said, hey, I'm pregnant. And he goes, hey, do you know, or he says, well, who's the father? Do you know? And that cost him a little bit of money, but something to keep in mind. And, you know, one of the top questions we're getting still from clients are 1099 and independent contractors in California. So we wanted to go over just very quickly with independent contractors and employees. You know, calling someone an independent contractor does not make them an independent contractor in the legal sense. And I hope we've all gotten away from hiring independent contractors over the last few years. I wish we had more time, but as you know, both California federal law apply to California workers, and California is just one of the most stringent in the country. There are lots of good reasons to have independent contractors, right? You don't have to pay their workers' comp, you don't have to pay employment taxes, you don't have to give them employee benefits, all of these things. However, there are risks involved, and there was Dynamex that came out 2 years ago. It came out in April, and it laid out an ABC test that I'll go over. And then, of course, AB5 passed in January of this year, and that changed things a lot for employers. And so the ABC test says, you know, part A is whether the worker is free from the control and direction of the hire in connection with the work. Part B is where everybody is having issues, whether the worker performs work that is outside the usual course of the hirer's business. And part C, whether the worker customarily engages in the trade involved in the work performed. However, and with this ABC test, it's A, B, and C, so you have to have all three. Now, with AB5, it lays out certain exemptions, and specific criteria has to be met, and these are the professions in which they are exempt. However, there are others, but each one of these has a whole host of things involved. So just because you're a grant writer doesn't mean you necessarily qualify, or a fine artist, or a travel agent, or a graphic designer. A lot of these still requires the hiring entity to establish that the individual maintains a location, has a business license, is able to negotiate and set their own rates, their own hours outside of project completion dates, and that they customarily perform the same type of work for others who are also hiring them, and that they hold themselves out to other potential customers. And of course, the bottom line for all of these is that the person exercises discretion and independent judgment in performing these services. So there are specific exempt occupations as well. Lawyers, of course, are on the list because we write the laws, but there are some specifics under each one of these as well. So if you have any questions, you know, Angela and I are here to answer specifically on whether or not you fall under an AB5 exemption, but there is also this catch-all business-to-business contracting, right? So it doesn't apply to a bona fide business-to-business contracting relationship if the business can satisfy all 12 of these criteria. So you have to check all 12 of these in order to qualify under the business-to-business exemption. And then if all 12 are met, then you apply Borello. So it's a multi-step test. And the Borello test, I'll go over the factors right now. Here are the factors, and I won't read them out to you. You can read them on the slide, but the ABC test and the Borello test certainly overlap, but the significant difference here to note is that the Borello test does not require a business to satisfy all of the factors listed above. Rather, the courts can consider and weigh factors in each case, making it more flexible and less demanding than the rigid AB5 test. Here are a couple best practices. Assume all workers are employees unless they clearly meet all the legal requirements and pass all the tests. That was a big thing that came out with Dynamex in April 2018 that says every single person who works for you is deemed to be an employee. And if you want to prove otherwise, you need to prove A, B, and C of the test. Okay, and then another best practice, when hiring an independent contractor, you want to properly report the engagement to EDD. Under certain circumstances, businesses and government entities who hire independent contractors must file reports with the EDD. When hiring an independent contractor, the law requires a report from anyone who is doing business in California, deriving trade or business income from sources within California or otherwise subject to California law. You know, I can't even tell you how many companies we've had to represent who are out of state and they decide to hire one person here in California, and then they open themselves up to California law and they get a misclassification lawsuit. So keep that in mind. Just one thing, when you have your employees working remotely, a couple things that I want to lay out is make sure you have a written agreement with them. You can say that this is just temporary, but it needs to outline the guidelines of allowing them to work from home. And you can say, you know, this will be in place as long as the California stay-at-home order is in place. You can give it some sort of time frame, but you want to describe in there who is eligible to work from home, because obviously not all jobs can be performed from off-site locations. It's important to ensure that the employee the expectations are laid out, right? Like the start time every day, the end time every day, being available and responsive throughout the day, that the person must still follow company procedures. Also, I think that companies are going to be hit big time for timekeeping systems, because so many businesses had to figure out how to have their employees work remotely. You know, I hope that everyone is still keeping track of meal periods and rest periods. I think that this is going to be a big issue come a year from now, when an employee says, hey, I've never been able to take a break, I've never been able to take a lunch, I was on Zoom meetings all day for you, I answered emails at night. You want to make sure that you have a very clear I do not work off the clock policy in your handbook, and that you are keeping track of meal and rest periods. And guys, it doesn't need to be anything fancy. You know, it could be a simple Excel spreadsheet. I clocked in on this day, I clocked out on this day, and they can turn it into you once a week. You know, Angela and I have also talked about, you know, you can have them send you an email every day of when they're clocking in or when they're clocking out, but just something so that something is documented. And then just one thing on reimbursable expenses, please make sure if you are having employees work from home that you are reimbursing them for a portion or all of it, if you want to be generous, of their cell phone and internet usage. There is case law that specifically says that a business cannot have a windfall by requiring an employee to use internet, and or the case actually says cell phone, for business operational expenses. And so it's really important. And there's no set amount. It just needs to be something that's reasonable. So one question we're getting here is internet and cell phone reimbursements, are they considered under the PPP? So if you've consistently been reimbursing your employees' cell phone and internet, yes, they are considered under the PPP. And
they're part of,
what's the reasonable?
They're not, if you're talking about reimbursements to employees, they're not considered utilities. They're actually considered, my understanding is that they're actually considered under payroll costs for the PPP,
yes.
purposes of the PPP.
Yes, thank you for clarifying. That's absolutely right. And then another question we are getting, what's a reasonable percentage of internet or cell phone use? 50%. I mean, I think 50% is reasonable. It can even be a set amount, because you know, you don't need to find out everyone's exact cell phone bill of $112 a month, $220 a month, $38 a month, and pay 50% of that. You can just make it a flat fee across the board for internet and cell phone. And I think, you know, it depends upon you, the business owner, to make that decision. Okay, and then—
Sorry, Cindy, this was
yeah.
on the chat as opposed to the Q&A. What if you don't require employees to work from home but allow them to? Are you required to pay for portions of the internet? If they are working from home, yes. If they are doing work that benefits the business while at home, it doesn't matter whether or not working from home is required or permitted. You must pay, because otherwise the business is receiving a windfall from the employees having internet.
Yes, exactly. And then no matter who your employment attorney is, please make sure you're checking in with them a couple times per year. You know, just minimum wage increases every June and every January and every July in LA. Specifically, LA is July, California is in January. And so if you have an experienced team of attorneys behind you, you know, everyone who works here at our firm has 10 to 20 years of legal experience. We are happy to help you. And then something we like to do early on when a client is facing any problem employee is do a liability assessment early on. Now, we have a lot of things for you guys, which I'm very excited for. We have an employment compliance checklist, and it's 19 things that you want to make sure you're doing with your employees. I'm happy to send that to anyone who texts HF Law. Text 66866 HF Law, and we will get you our checklist. Also, because so many things are happening right now, we are doing our best to just pump out as much information as we can to our clients, of course, but also our friends. And so, you know, the Department of Labor came out with a new poster a couple weeks ago. We wanted to make sure everyone got that. So we pushed that out. We do not spam you guys, or at least I don't think we do, but something that we've developed is an addendum to add to your employee handbook. I'll be sending that out hopefully this afternoon. I also created a welcome back letter that you can send to your employees and hopefully use that if you find that helpful. And I hope that by now everyone got our COVID-19 response plan. It was a couple pages, and it just, you know, has you basically what to do if someone gets sick with COVID in your workplace. And yeah, any other questions? It is exactly noon, and we like to end and start at exactly on time. So with that being said, Angela and I want to thank you for joining us this morning, and we wish you a great weekend.